The only voice that matters is the voice of the jury, and the jury has spoken.
A jury of 12 Manhattan residents reaches an historic verdict. Donald Trump guilty on all counts. He is now the first former president to become a convicted felon. Good evening. I'm Maurice Dubois.
And I'm Christine Johnson. Trump was found guilty on 34 counts of falsifying business records.
His sentencing set for July 11th at 10 a.m., just days before Republicans are set to formally nominate him for president.
His former fixer, Michael Cohen, who testified against his old employer, walked out of his apartment tonight saying nothing. But in a post on social media, he said in part, "Today is an important day for accountability and rule of law. While it has been a difficult journey for me and my family, the truth matters."
It was June of 2015, almost exactly 9 years ago, when Donald Trump descended the escalators at Trump Tower to announce his run for the presidency. Tonight, he returned to that very building as a convicted felon.
All right, Adam in the building, let's make some noise. Outside the courthouse, Trump screams, "Witch hunt," to roaring crowds. Inside, judges and jurors quietly build a permanent legal record. The contrast between theatrical spectacle and cold documentation defines this moment, as court documents accumulate at a staggering rate. Let me take you inside the room where the most consequential criminal trial in American history unfolded. The judge assigned to the case was someone who had spent decades on the bench, handling complex criminal matters with a reputation for being no-nonsense, methodical, and utterly unimpressed by celebrity or political status. He had seen it all, or so he thought, before this case landed in his courtroom. From the very beginning, he made it clear that this would be a criminal trial like any other, with rules that applied equally to every participant, regardless of their station in life. He issued a standard protective order, something that happens routinely in high-profile cases, barring the defendant from making public statements about jurors, witnesses, court staff, or their families.
Testimony is underway in the third week of the criminal hush money trial involving former President Donald Trump. Today, the judge in the case held Trump in contempt of court for violating a gag order. Judge Juan Merchan says Trump violated the order not one, but 9 times, and fined him, $1,000 each, total of $9,000. CBS News correspondent Errol Barnett is following this for us outside the courthouse in Manhattan. Errol, you've been there day in and day out. Talk to us about this decision today. This is new news this morning, and the warning to Trump that it's not just about paying fines. He could end up in jail for this.
That's exactly right, Lilia. Judge Juan Merchan now instituting some level of punishment to former President Donald Trump for what he says is a clear violation of 9 instances of the judge's gag order.
It was a routine precaution designed to ensure that the trial could proceed without intimidation or outside influence affecting the participants. What followed was anything but routine. The defendant violated that order not once, not twice, but repeatedly, posting about witnesses on social media, commenting on the composition of the jury in radio interviews, and generally treating the court's authority as something optional rather than binding. The judge responded with escalating sanctions, fines that maxed out the statutory limit, direct warnings delivered in open court, and ultimately, a written order that put the defendant on formal notice that further violations would result in incarceration. The moment when the judge addressed the defendant directly in open court is one that everyone present will remember. He acknowledged the unusual circumstances, the fact that he was dealing with a former president who might well become president again, and he said the magnitude of the decision was not lost on him. But then he delivered the line that sent shockwaves through the courtroom. He said, "At the end of the day, I have a job to do, and if necessary and appropriate, I will impose a jail sanction."
Well, a judge has issued a gag order on Donald Trump in his upcoming hush money criminal trial here in New York. Prosecutors requested the gag order, citing what they call the former president's long history of making public and inflammatory remarks about people involved in his legal cases. The order bans Trump from making public comments about witnesses, prosecutors, court staff, and jurors involved in the trial. The cases stem from alleged hush money payments made to adult film actress Stormy Daniels. Trial is set to begin on April 15th.
That statement, delivered in the measured tone of a judge who had clearly thought through every implication, was followed by a written order that formalized the warning. The combination of the oral statement and the written order created a permanent judicial record that a former president of the United States had been warned that his next violation of a court order would land him in a cell. Think about the significance of that for a moment. This wasn't a political opponent making a campaign ad. This wasn't a media commentator offering an opinion. This was a sitting judge, on the record, in writing, telling a defendant that he was one step away from incarceration. The language was precise, the warning was clear, and the documentation was permanent. And then came the verdict. After weeks of testimony, after the presentation of documentary evidence and financial records and first-hand accounts from people who were in the room, the jury returned with something that stunned even the most seasoned court watchers. A unanimous verdict on all 34 felony counts, reached in less than 12 hours of deliberation.
President Donald Trump has long railed against the Democratic New York Attorney General. While campaigning for her office, Letitia James referred to him as an illegitimate president and promised to investigate him. And she did. Before his election victory, Letitia James successfully sued him and his beloved Trump organization for fraud, something he denounced as a witch hunt.
That is, he inflated his statements of financial interests to enrich himself and his family.
The civil penalty included a judgment of $500 million after interest and barred him and his sons from doing business in New York for years. After he appealed, a New York state court threw out the penalty in August, but upheld the judge's finding that Mr. Trump was liable for fraud. Now, Donald Trump promised retribution for those he deemed his enemies during his campaign.
When we win back the White House, we will have no higher priority than ending the weaponization of this horrible legal system that is developed around us.
The speed of the verdict, combined with its unanimity, told its own story about the clarity of the evidence as the jury understood it. Count by count, the finding was read into the record. Guilty, 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 repeated 34 times. Each count represented a documented finding by 12 citizens who had heard weeks of testimony and examined reams of documentary evidence. The verdict meant that the jury had found beyond a reasonable doubt that the defendant had falsified business records, that he had disguised reimbursements as legal fees when they were actually payments for hush money, and that he had done all of this to conceal conduct that could have affected the outcome of the 2016 presidential election. The guilty verdict on 34 felony counts is now a permanent part of the judicial record. The appeals process may change the penalty. It may produce rulings on specific procedural questions, but the factual finding of guilt by a unanimous jury is not going to be erased from history. The contempt findings that accumulated during the trial are almost as significant as the verdict itself, because they document something that the verdict does not capture. The verdict tells you what the defendant did in 2016. The contempt findings tell you what he did in 2024 while standing in a courtroom, while being told repeatedly that his behavior was violating a court order. Each of the 10 contempt findings identifies a specific act, a specific post, a specific statement, and makes a specific legal determination that the act violated the specific language of the court's order. The findings document that the defendant knew about the order. They document that he made the prohibited statement anyway. They document that the statement fell within the prohibited categories, and they document the specific sanction imposed. The cumulative pattern revealed by those 10 findings is genuinely revealing. A defendant who violated a court order 10 times, who was held in contempt 10 times, who was fined 10 times, and who was warned in writing that the next violation would lead to jail. That pattern is now permanently in the case file, available for historians and legal scholars and future prosecutors to examine and assess. The official language of the courtroom stands in stark contrast to the language that echoed outside the courthouse walls. Inside, the words were precise and measured and legally significant. Convicted, felony, contempt, probable cause, incarceration. Outside, the words were something else entirely. Witch hunt, rigged, corrupt, hoax. The contrast between these two vocabularies, one rooted in the careful procedures of American jurisprudence and the other rooted in the raw emotions of political combat, could not be more complete. The screaming outside was real, no question about it, but the record inside was also real, and it was the record that would survive. The judge who presided over the trial was not a partisan actor. He was an experienced jurist who had been assigned to the case through the normal judicial assignment process. Lawyers who appeared before him, including defense lawyers whose job it was to find fault with his rulings, described him as firm but fair. He applied the gag order to all parties, not just the defendant. He sustained objections from both sides at various points in the trial. He ran proceedings that produced a unanimous jury verdict in less than a day of deliberation. The American Bar Association's standards for judicial conduct, long established and widely respected, were applied by every observer who examined his conduct, and no reviewing court found that he had failed to meet those standards in any way that required reversal. But the story doesn't end with the hush money trial, because the judicial record about Trump and his administration is being built across multiple courtrooms. In Washington, a federal judge named James Boasberg was dealing with a different kind of defiance, one that involved the Trump administration's treatment of a court order in a deportation case. The sequence of events was alarming. Boasberg had issued an emergency restraining order, blocking the administration from deporting Venezuelan migrants to El Salvador under a law that dated back to 1798. The administration's response was to fly the planes anyway. While Boasberg's order was either being entered or was already in effect, 2 planes departed American soil, flew to El Salvador, and landed with over 260 people aboard who were placed in a notoriously violent prison. The president of El Salvador mocked the judge on social media, posting the words "oopsie too late" above a news article about the restraining order. When Boasberg investigated what had happened, he issued a 46-page ruling that made findings that would have been unimaginable in any previous administration. He found probable cause to hold the administration in criminal contempt. He wrote that the administration had shown willful disregard for his order. And he wrote that the Constitution does not tolerate willful disobedience of judicial orders, especially by officials of a coordinate branch who have sworn an oath to uphold it. Let me take you deeper into the Boasberg ruling because it represents something genuinely extraordinary in American legal history. The Chief Judge of the United States District Court for the District of Columbia, one of the most powerful trial judges in the federal system, sat down and wrote a 46-page opinion that accused the United States government itself of criminal contempt of court. He wasn't talking about some minor procedural violation. He was talking about the deliberate defiance of a binding court order by the executive branch, a co-equal branch of government that had sworn to uphold the Constitution. The language of his ruling was stark and uncompromising. He said the administration's lawyers had argued that the migrants were over international waters when the written order was formally entered, a contention he described as one heck of a stretch. He said the administration had shown willful disregard for his order, and he gave the administration a path to purge the contempt by returning the migrants to U.S. custody so they could challenge their deportation in court. He also warned that if the Justice Department declined to prosecute the matter, he would appoint a separate attorney to do so. Can you believe this? A federal judge threatening to appoint his own prosecutor to go after administration officials for criminal contempt. That level of judicial escalation is extraordinarily rare in American legal history. It simply does not happen, except when judges have concluded that they are dealing with an executive branch that will not voluntarily comply with court orders. The appeals court eventually vacated the contempt finding on procedural grounds, ruling that the specific mechanism Boasberg had used was not the proper way to pursue criminal contempt against administration officials. But the underlying finding, the documented judicial conclusion that the administration had shown willful disregard for a court order, was not vacated as legally wrong. It was left intact as a factual matter. The 46-page opinion remains in the public record, a permanent document that historians and future investigators can examine. The procedural ruling did not erase the fact that a federal judge had found probable cause that the administration had deliberately defied a court order. It simply changed how that finding would be pursued if anyone decided to pursue it further. The record of judicial confrontation that Boasberg created is part of the permanent archive of American legal history, alongside the hush money conviction and the contempt findings. The suppression of Jack Smith's report is another chapter in this ongoing story, and it represents something that legal scholars will be debating for decades. Smith, the special counsel who had been investigating Trump's conduct, issued a final report in 2 volumes. The first volume, covering the federal election interference case, was released to the public. It described in detail the evidence assembled over years of investigation, the legal theories prosecutors had developed, and Smith's own assessment that the admissible evidence was adequate to obtain and sustain a conviction at trial. That assessment is now part of the public record, a formal document from the United States Department of Justice stating that a federal prosecutor had built a case sufficient to convict the President of the United States of election interference crimes. The second volume, covering the classified documents case at Mar-a-Lago, was a different story entirely. That volume was blocked from public release by Judge Eileen Cannon, a Trump appointee who had presided over the classified documents case before it was dismissed following Trump's election victory. Cannon ruled that releasing the second volume would be a manifest injustice, given the Justice Department policy that prevented prosecution of a sitting president. She argued that releasing evidence from a case that could not proceed to trial was unfair, because the defendant could not meaningfully respond to it. The result is a bizarre situation in which the public knows what Smith concluded about the classified documents case, that it was one of the most detailed and specific obstruction cases in American legal history, but cannot read the actual evidence that led him to that conclusion. The government's own investigators had assembled surveillance footage, employee testimony, and documented obstruction evidence. Legal experts who were briefed on the contents called it damning and highly detailed. But all of that remains sealed, available only to prosecutors and judges who have proper authority to access it. The suppression itself is part of the judicial record, just as the government's assessment of what it found is part of the record. The gap between those two facts, between what prosecutors found and what the public is allowed to read, is a permanent feature of the historical record. Future historians, congressional investigators, and prosecutors will be working with that gap for years to come, trying to understand what was hidden and why. Now let's talk about the broader pattern of judicial findings that have accumulated over time. Because the cumulative weight of what courts have documented about Trump and his administration is genuinely staggering. We're not dealing with a single indictment or a single conviction. We're dealing with multiple cases across multiple jurisdictions, federal and state, criminal and civil, each producing its own set of documented findings. The hush money conviction, with its 34 felony counts and 10 contempt findings. The Boasberg probable cause ruling with its finding of willful disregard for court orders. The Smith report with its assessment that the evidence was adequate to convict. The Georgia RICO case with its 41 counts and 19 defendants. The classified documents case with its documented obstruction evidence that remains sealed. Each of these is a separate piece of the judicial record, each documented by different courts and different judges, each producing findings that are now permanently part of American legal history. The pattern that emerges from this accumulated record is one of persistent defiance of legal and institutional constraints. The contempt findings show a defendant who repeatedly violated court orders even after being warned that further violations would result in incarceration. The Boasberg ruling shows an administration that defied a federal judge's order and then tried to argue that it hadn't happened. The Smith report shows a prosecutor who concluded he had sufficient evidence to convict, only to have the case dismissed because the defendant was elected president. The Georgia case shows a former president and his allies facing prosecution under state law that cannot be pardoned by federal executive action. Each of these cases, each of these findings, each of these judicial documents adds to the body of evidence that courts have formally assessed and documented about Trump's conduct and the conduct of his administration. What makes all of this especially significant is the contrast between the judicial record and the public narrative that Trump has constructed around himself. The judicial record uses precise, technical language that has very specific legal meanings. Words like convicted, felony, contempt, probable cause, and incarceration. Each of those words has been applied to Trump or his administration by a court of law. Each finding has been documented in a written opinion or order, and each of those documents is now part of the permanent public record. Trump's public narrative uses very different language. Witch hunt, rigged, corrupt, hoax, certified Trump hater, radical left lunatic. The contrast between the two vocabularies reflects a deeper contrast between two ways of understanding what has happened. One is rooted in the careful procedures of American jurisprudence, the other in the emotional dynamics of political combat. One is documented in official court records, the other in social media posts and rally speeches. The courts are not immune to political dynamics, and no one is suggesting otherwise. Judges are appointed by politicians, confirmed through political processes, and operate within a broader political environment. But the procedures of American courts are designed to filter out the worst effects of political influence. The requirement that judges be impartial, that evidence be presented under rules, that juries be instructed on the law, that verdicts be unanimous. All of these are safeguards against the kind of raw political judgment that dominates the world outside the courtroom. The documents that courts produce, the opinions and orders and findings, are the product of these procedures. They carry weight precisely because they come out of a process that is designed to be fair and accurate. And that is why the judicial record is so important. It represents a version of events that has been subjected to the scrutiny of adversarial proceedings, reviewed by trained judges, and validated by citizens serving on juries. Think about what it means that a unanimous jury found Trump guilty on 34 felony counts. That doesn't mean that everyone agrees with the verdict or that there won't be arguments about it on appeal, but it does mean that 12 ordinary citizens, chosen from the community, heard weeks of evidence and concluded beyond a reasonable doubt that Trump committed those crimes. That is not a political opinion. It is a legal finding, made under oath, documented in the official record, and carrying the full weight of American law. The same is true of the contempt findings. Those are not political accusations. They are court orders that have been violated, documented by a judge who found specific violations of specific orders. The Boasberg ruling is not a political statement. It is a judicial finding that an administration showed willful disregard for a court order. The permanent nature of these judicial findings is something that defenders of Trump often try to minimize or dismiss. They say the trials were politically motivated, the judges were biased, the system was rigged, but the record exists regardless of these claims. The documents are in the courthouse files. The opinions are published on legal databases. The verdicts are recorded in the official minutes of the proceedings. No amount of screaming outside the courthouse can change what is written inside the courthouse. The judge who presided over the hush money trial did not get his assignment through political favoritism. He was a career jurist with decades of experience on the bench. Lawyers who appeared before him, including those representing Trump, have described him as fair and professional. The evidence presented at trial, including the financial records and testimony from witnesses who were in the room, was subjected to cross-examination and legal challenges. The jury that rendered the verdict was selected through a process designed to produce a fair and impartial panel. None of this is to say that the system is perfect or that there were no issues in the trial. Every trial has issues, and appeals are a normal part of the process. But the basic structure of the proceedings was consistent with the American legal tradition, and the findings that emerged from those proceedings are now part of the permanent record of American history. Now, let's consider what this cumulative judicial record means for how history will understand this period. Historians 100 years from now will not be relying on Trump's social media posts or rally speeches to understand what happened. They will be reading court documents, examining trial transcripts, studying judicial opinions. They will see that a former president was convicted by a unanimous jury of 34 felony counts. They will see that he was held in contempt of court 10 times. They will see that a federal judge found probable cause that his administration had willfully defied a court order. They will see that a special counsel concluded he had sufficient evidence to convict the president of election interference crimes. These are not allegations. These are documented findings, produced through established legal procedures and recorded in official documents that will survive as long as American legal records survive. The screaming outside the courthouse will be a footnote, a historical curiosity, a reminder of how heated the politics of the era were, but the documents inside the courthouse will be the primary evidence that historians use to understand what happened. The significance of the judicial record extends beyond its historical value. It has real implications for how the legal system operates going forward. The contempt findings established a precedent about what happens when a high-profile defendant repeatedly violates a court order. The Boasberg ruling established a precedent about what happens when an administration defies a federal judge's order. The Smith report established a precedent about how special counsel investigations are concluded and how their findings are reported to the public. The Georgia case established a precedent about how state prosecutions can proceed against a former president. All of these precedents will shape how future cases are handled, how judges respond to defiant defendants, how administrations interact with courts, and how prosecutors pursue cases against powerful figures. The judicial record is not just about the past. It is about the future, about how American law will operate in an era when the barriers that once seemed unbreakable have been breached. And that is why the documents being generated inside the courthouses are so important. They are not just historical records. They are legal foundations, institutional safeguards, and permanent guideposts for how the system will function in the years to come. Consider what the 10 contempt findings collectively reveal about the relationship between the defendant and judicial authority. Each finding was a specific determination that a specific act violated a specific order. The first 9 were punished with fines, the maximum allowed by statute. The 10th led to a formal warning about incarceration. The pattern shows someone who was not deterred by financial penalties, who continued to violate the court's order even after being told that future violations would lead to jail. This is not a pattern of inadvertent violations. It is a pattern of deliberate defiance. And the judge who documented this pattern found it significant enough to put on the record that the fines were not sufficient, that the threat of incarceration was the only thing that might work. That judgment, that judicial assessment of what it would take to deter this particular defendant from violating court orders, is part of the permanent record. The Boasberg ruling adds another dimension to this picture. It is not about a defendant violating a court order in the context of a criminal trial. It is about an entire administration violating a court order in the context of immigration enforcement. The scale is different. The implications are different. When a criminal defendant violates a gag order, it is a serious matter, but it is a contained one. When an administration defies a federal judge's order and flies 2 planes full of people out of the country, it is a constitutional crisis. Boasberg understood that, which is why his language was so strong and his findings so direct. He wasn't just punishing a defiant litigant. He was defending the authority of the judicial branch against a co-equal branch that had decided to ignore its orders. The 46-page opinion is a monument to the importance of judicial authority in a constitutional system. It says clearly and forcefully that the executive branch cannot simply ignore court orders. It says that the Constitution does not tolerate willful disobedience. It says that officials who have sworn an oath to uphold the Constitution are bound by that oath, even when they disagree with the judge's ruling. The suppressed Smith report is the third pillar of this judicial record, and in many ways the most troubling. Here is a special counsel appointed through proper procedures, conducting an investigation that produced evidence of criminal conduct. His conclusion, stated publicly, was that he had adequate evidence to convict at trial. And yet that conclusion was followed by a decision not to prosecute because of a Justice Department policy that prevents the prosecution of a sitting president. The policy is not unconstitutional. It is a long-standing departmental rule that has been followed by administrations of both parties. But it means that the president, unlike every other American, cannot be prosecuted while in office. The result is a gap between what prosecutors found and what they were able to do about it. That gap is documented in the Smith report, in Cannon's order, and in the public statements of all concerned. It is a gap that future Congresses may investigate, future courts may address, and future historians will certainly analyze. Across multiple courts, a consistent portrait emerges. Persistent defiance of legal constraints. Treating judicial authority as something to be managed rather than obeyed, from hush money contempt to Boasberg's order to the Smith report and Georgia case. The judicial record is growing permanently. While the noise outside fades, the documentation inside will define history.